New York Times Company v. Sullivan, 376 U.S. 254, was a landmark United States Supreme Court case that established the actual malice standard, which has to be met before press reports about public officials can be considered to be defamation and libel, and hence allowed free reporting of the civil rights campaigns in the southern United States. It is one of the key decisions supporting the freedom of the press. The actual malice standard requires that the plaintiff in a defamation or libel case prove that the publisher of the statement in question knew that the statement was false or acted in reckless disregard of his truth or falsity. Because of the extremely high burden of proof on the plaintiff, and the difficulty of proving the defendant's knowledge and intentions, such cases when they involve public figures rarely prevail. Before this decision, there were nearly $300 million in libel actions outstanding against news organizations from the southern states, and it had caused many publications to exercise great caution when reporting on civil rights, for fear that they might be held accountable for libel. After the New York Times prevailed in this case, news organizations were free to report the widespread disorder and civil rights infringements. The Times maintained that the case against it was brought to intimidate news organizations and prevent them from reporting illegal actions of public employees in the South as they attempted to continue to support segregation. Background of the case: on March 29, 1960, the New York Times carried a full-page advertisement titled "Heed Their Rising Voices," which solicited funds to defend Martin Luther King, Jr. against an Alabama perjury indictment. The advertisement described actions against civil rights protesters, some of them inaccurately, some of which involved the police force of Montgomery, Alabama. Discrepancies were generally minor. Referring to the Alabama State Police, the advertisement stated, "They have arrested King 7 times." However, at that point he had been arrested 4 times. Although African American students staged a demonstration on the state capitol steps, they sang the national anthem and "Not My Country, 'Tis of Thee." Although the Montgomery Public Safety Commissioner, L.B. Sullivan, was not named in the advertisement, the inaccurate criticism of actions by the police was considered defamatory to Sullivan as well, due to his duty to supervise the police department. Alabama law denied a public officer recovery of punitive damages in a libel action concerning their official conduct unless they first made a written demand for a public retraction and the defendant failed or refused to comply, so Sullivan sent such a request. The Times did not publish a retraction in response to the demand. Instead it wrote a letter stating, among other things, that "We are somewhat puzzled as to how you think the statements in any way reflect on you, and you might, if you desire, let us know in what respect you claim that the statements in the advertisement reflect on you." Sullivan did not respond but instead filed a libel suit a few days later. He also sued 4 African American ministers mentioned in the ad, specifically Ralph Abernathy, SSI, SR, Fred Shuttlesworth, and Joseph Lowry. Sullivan won $500,000 in an Alabama court judgment. The Times did subsequently publish a retraction of the advertisement upon the demand of Governor John Patterson of Alabama, who alleged the publication charged him with grave misconduct and improper actions and omissions as governor of Alabama and ex officio chairman of the State Board of Education of Alabama. When asked to explain why there had been a retraction for the governor but not for Sullivan, the secretary of the Times testified, "We did that because we didn't want anything that was published by the Times to be a reflection on the state of Alabama, and the governor was, as far as we could see, the embodiment of the state of Alabama and the proper representative of the state, and, furthermore, we had by that time learned more of the actual facts which the ad purported to recite, and, finally, the ad did refer to the action of the state authorities and the Board of Education, presumably of which the governor is the ex officio chairman." However, the secretary also testified he did not think that any of the language in there referred to Mr. Sullivan. Louis M. Loeb, a partner at the firm of Lord Day & Lord, served as chief counsel to the Times from 1948 to 1967, successfully argued this case before the United States Supreme Court. The court's ruling held that news publications could not be sued for libel by public figures unless the plaintiffs were able to establish actual malice in the false reporting of a news story. The case, which had been brought against the Times by Montgomery, Alabama Public Safety Commissioner L.B. Sullivan, allowed newspapers to report on the widespread chaos and police abuse accompanying the civil rights movement. Loeb later called the libel cases he argued for the New York Times the heaviest responsibility unregistered trademark they ever had since I began practicing law. 1. The court's decision. The court ruled for the Times, 9-0. The rule of law applied by the Alabama courts was found constitutionally deficient for failure to provide safeguards for freedom of speech and of the press, as required by the First and 14th Amendment. The decision further held that even with the proper safeguards, the evidence presented in this case was insufficient to support a judgment for Sullivan. In sum, the court ruled that the First Amendment protects the publication of all statements, even false ones, about the conduct of public officials except when statements are made with actual malice. Actual malice equals, the court held that a public official suing for defamation must prove that the statement in question was made with actual malice. In this context, the phrase refers to knowledge or reckless lack of investigation, rather than its ordinary meaning of malicious intent. In his concurring opinion, Justice Black explained that, malice, even as defined by the court, is an elusive, abstract concept, hard to prove and hard to disprove. The requirement that malice be proved provides at best an evanescent protection for the right critically to discuss public affairs and certainly does not measure up to the sturdy safeguard embodied in the First Amendment. The term malice was not newly invented for the case. It came from existing libel law. In many jurisdictions, including Alabama, proof of actual malice was required in order for punitive damages to be awarded, or for other increased penalties. Since a writer's malicious intent is hard to prove, proof that the writer knowingly published a falsehood was generally accepted as proof of malice, under the assumption that only a person with ill intent would knowingly publish something false. In Owetner v. Dunkirk Printing Company, 254 NY 95, similarly, the court said, the plaintiff alleges that this criticism of him and of his work was not fair and was not honest. It was published with actual malice, ill will and spite. If he establishes this allegation, he has made out a cause of action. No comment or criticism, otherwise libelous, is fair or just comment on a matter of public interest if it be made through actual ill will and malice. In New York Times Company v. Sullivan, the Supreme Court adopted the term actual malice, giving it constitutional significance. International comparisons. The rule that somebody alleging defamation should have to prove untruth, rather than that the defendant should have to prove the truth of a statement, stood as a departure from the previous common law. In England, the development was specifically rejected in Derbyshire County Council v. Times Newspapers Limited, and it was also rejected in Canada in Hill v. Church of Scientology of Toronto and more recently in Grant v. Torstar Corporation in Australia. The outcome of the case was followed in Theophanous v. The Herald and Weekly Times Limited, but Theophanous was itself overruled by the High Court of Australia in Lang v Australian Broadcasting Corporation 189 CLR 520. 50th anniversary. In 2014, on the 50th anniversary of the ruling, the New York Times released an editorial in which it stated the background of the case, laid out the rationale for the Supreme Court decision, critically reflected on the state of freedom of the press 50 years after the ruling and compared the state of freedom of the press in the United States with other nations. The editorial board of the New York Times heralded the Sullivan decision as the clearest and most forceful defense of press freedom in American history, and added, "The ruling was revolutionary, because the court for the first time rejected virtually any attempt to squelch criticism of public officiality even if false was antithetical to the central meaning of the First Amendment today. Our understanding of freedom of the press comes in large part from the Sullivan case. Its core observations and principles remain unchallenged, even as the Internet has turned everyone into a worldwide publisher capable of calling public officials instantly to account for their actions, and also of ruining reputations with the click of a mouse." Later developments. Curtis Publishing Company v. Butts, 388 U.S. 130 held that public figures who are not public officials may still sue news organizations if they disseminate information about them which is recklessly gathered and unchecked. Gertz v. Robert Welch, Incorporated, 418 U.S. 323, actual malice not necessary for defamation of private person if negligence is present. Hustler Magazine v. Falwell, 485 U.S. 46, extending standard to intentional infliction of emotional distress. Milkovich v. Lorraine Journal Company, 497 U.S. 1, existing law is sufficient to protect free speech without recognizing opinion privilege against libel claims. See also, New York Times Company v. Ticini, New York Times Company v. United States, List of United States Supreme Court Cases, Volume 376. Notes. Further reading, Burnett, Nicholas F. New York Times v. Sullivan. In Parker, Richard A. Free Speech on Trial, Communication Perspectives on Landmark Supreme Court Decisions. Tuscaloosa, Alabama, University of Alabama Press pages 116-129. ISBN 0-8173-1301-X. Lewis, Anthony. Make No Law, The Sullivan Case and the First Amendment. New York, Random House. ISBN 0-394-58774-X. Fireside, Harvey. New York Times v. Sullivan, Affirming Freedom of the Press. Berkeley Heights, New Jersey, Ainlow Publishers, Incorporated. ISBN 978-0-7660-1085-7. Lithwick, Dahlia. Target Practice, Justice Scalia sets his sights on New York Times Company v. Sullivan. Slate. Retrieved March 25, 2013. Watson, John C. Times v. Sullivan, Landmark or Landmine on the Road to Ethical Journalism? Journal of Mass Media Ethics 17, 3 doi, 10.1207 per second 15327728 JMME 170102. External links, text of New York Times Company v. Sullivan, 376 U.S. 254 is available from Findorgeist U of Wisconsin BC, OYEZ New York Times v. Sullivan, Booknotes interview with Anthony Lewis on Make No Law, The Sullivan Case and the First Amendment, October 20, 1991.